We are live.
Oh yay, oh yay, oh yay. The Honorable Court of Appeals for the 7th District of Texas is now in session.
Thank you, Mr. Ramirez. Good afternoon, gentlemen. My name is Pat Pirtle. I'll be presiding on this panel today in the case of Cathleen Ann White versus the state of Texas. Serving with me today is the Honorable Justice Judy Parker and the Honorable Justice Larry Doss. Counsel, just to kind of give you some background, normally by this time, counsel, the court has read your briefs, but we may not have made an in-depth look into the record of the case. So if we ask some questions about the record, you'll understand that. We do often ask questions. Asking has been a little bit different now that we're doing things virtual. So just kind of bear with us as we go through things here. Mr. Alderetti, as the appellant, you'll have 20 minutes for your direct arguments. The state will then have 20 minutes in response, and then the appellant will have a final 5-minute rebuttal. You can use all of that time or any part of it, and the clock there is in the corner so that you can keep track of that. Do you have any questions? There being none, council will go ahead then and formally call cause number 0720-00048 CR Kathleen Ann White versus the state of Texas. Here today for the appellant is Charles Alderetti. Mr. Alderetti, are you ready to proceed?
Yes, sir. Sure.
And for the state, Mr. Willem Van Zeeben. Mr. Van Zeeben, are you ready to proceed?
Yes, Your Honor.
All right. Appellant may address the court.
May it please the court. My name is Charles Alderetti, and I represent the appellant, Kathleen Ann White. I would like to reserve 5 minutes for rebuttal, please.
You will have 5 minutes for rebuttal.
Thank you. I would like to focus on 2 issues today. The first is related to the legal sufficiency argument, and the second is related to the evidentiary argument. The primary issue for review here centers on whether the variance in the indictment was material. If it is deemed material, the evidence is legally insufficient to support the conviction. A hypothetical jury charge must include material variances. The state seems to agree that there is a variance between the indictment and the charge, but the question is whether the variance is material and must be proved. If the variance is material, then it must be included in the hypothetically correct jury charge and that element. A statutory allegation that defines the offense is always material. The statutory language in the indictment required the state to prove that the act purported to be of Gino Halili because it tracked the statutory definition of forgery. The Penal Code section 32.12b states, quote, a person commits an offense if he forges a writing with intent to defraud or harm another. To determine whether one has forged a writing, one must look at the definition of forge within that section. Forge can mean one of 3 things, and they are as follows. First, for subparagraph A, to alter, make, complete, or authenticate any writing so that it purports to either be the act of another who did not authorize that act, 2, to have been executed at a time or place or in a numbered sequence other than was in fact the case, or 3, to be a copy of an original when no such original exists. Alternatively, the state can show section B, which is to issue, transfer, register the transfer, pass, publish, or otherwise utter a writing that is forged within the meaning of paragraph A. Or the third option is C, to possess a writing that is forged within the meaning of paragraph A with the intent to utter it in a manner specified in paragraph B. The indictment here alleged that Ms. White passed a writing knowing that it had been made so that it purported to be an act of Gino Halili, Representative Costantino.
Mr. Alderetti, your audio is breaking up.
I apologize.
I want to make sure we get it. Okay.
Is that better?
Yeah, we're better. We're good.
Thank you. So as I was saying, the indictment here alleged that Ms. White passed a writing knowing that it had been made so that it purported to be the act of Gino Halili, a representative of Pasta Fina Italian restaurant, who did not authorize the act. In making this allegation, the state chose to charge Ms. White with specifically violating 32.12 A1B and 32.12 A1A, which must be proved to satisfy paragraph B. Now, to satisfy paragraph A, the state chose to go with Roman numeral 1, which is that the writing purports to be the act of another who did not authorize that act. The forgery statute does not define another, but the penal code does in section 1.07A.
So, counsel, are you contending that the indictment's identification of another is a statutory allegation, like an indictment's express identification of a particular manner and means allegation?
Yes, Justice, and that is because another is it is part of that section, and another itself is a defined term within the penal code. So when you have it breaking it down into, it's defined as a person other than the actor, and then a person is either an individual, corporation, LLC, etc., or some other entity governed by the Business and Commerce Code. So when you apply those definitions and you can state the forgery statute as follows, it can be stated as to alter, make, complete, execute, or authenticate any writing so that it purports to be the act of an individual or an entity, corporation, etc. So in that, because it's part of those definitions and they are defined terms, they are part of the statute. And when you include them in there, it's more obvious because they aren't in the forgery section itself, but they are defined terms in the penal code. And so those cannot be ignored. And because they relate to that definition are required to get to the definition of forgery, they are material and part of the charge.
Mr. Aldretti, is purport defined in the forgery statute?
I don't believe so.
Did anybody request a definition in the charge of the word purport?
Yeah, to my knowledge, that was not raised as an issue.
The reason I'm asking is that my understanding of the word purport focuses on the conduct of the person transmitting the information. Your brief focuses a lot on how the recipients received the information or processed the information in a certain way. That doesn't seem to satisfy what purporting is if we just focus on the act of your client.
Well, Justice, I think in this case, with the forgery statute, there are a couple of other issues at play because it kind of goes two ways into who the statute is protecting. Obviously, there has to be an intent to defraud or harm another, but especially with checks, that can go several ways. You could be defrauding. You could be, for example, hypothetically signing someone's signature on a forged check and getting money from their bank account, or you could be taking it to a check cashing place and you're getting the money from them with the expectation that the bank reimburses them. But so there are different elements as to how forgery works, and so I think the focus really is on these words in that purport. I guess it could be read to protect an individual, but because the statute protects in different ways, it's important to understand who another is, and I think that supports the position that they had to identify the person.
Well, let me
You're
ask you a
not
question.
contending. Oh, excuse me. You're not contending that the check purported to be the act of an entity outside of the definition, the statutory definition of another, are you?
No, Madam Justice. Here, our position is that the state alleged that it purported to be an act of an individual, specifically Mr. Halili. So because the evidence didn't show that the conviction should have been overturned. By pleading that, by specifically focusing on that definition of another, the state then had to prove that it was the person. And so it's not our position. So it's our position they failed to do that.
Well, in the application paragraph, it says, and such writing had been so made that it purported to be the act of Gino Halili, a representative of Pastafina Italian restaurant.
That is correct. But if we continue, it also says who did not authorize that act. So I believe that the phrase a representative of Pastafina restaurant is really only descriptive of Mr. Halili and can be omitted from that paragraph. So without that, it's Gino Halili who did not authorize the act. It turns on who's doing the authorization. It's not reading as Pastafina did not authorize the act. As it's written, I believe that it shows that Gino Halili is the one who did not authorize the act. So in this case, because the state focused on Mr. Halili in the indictment, and this is part of a critical term, it had to have been proved, and none of the evidence showed that the act purported to be one of Mr. Halili's. He testified at trial that the act did not purport to be his. The signatures don't match. He made a signature at trial and it does not match the signature on the check or come anywhere close to it. And so for these reasons, the evidence would be legally insufficient to support the conviction and it should be overturned.
And that gets me back to my question. This is where I'm trying to understand. Without regard to whether we think there's an additional element that's foisted on as a result of this additional language, or whether we consider it surplusage, does it matter under these circumstances? So long as the evidence was before the jury that contained Mr. Halili's name, whether it was identified as his, whether it was written on a different account, the fact that the name existed, doesn't that satisfy the definition of purporting to be another individual under the statute, without regard to whether she was successful in getting away with it or not?
I'm sorry, I don't believe that it does satisfy that it's another. So it does satisfy that. And that's the issue, though, is that they had to prove that specifically, that it was an act of, that it purported to be an act of Gino Halili. So yes, by including that in the indictment and charge, it does satisfy that element and it tracks the statute in its definitions. And so the issue is whether that had to be included in the hypothetical jury charge, which our position is yes, because it is part of an essential element, and then whether the evidence was legally sufficient to support a conviction. And the evidence was not. You applying the correct hypothetical jury charge with Mr. Halili as the individual who purported to make the act, and the evidence just simply doesn't show that.
Under Gollyhar, which I understand you say this case does not fall under Gollyhar, but a variance between the wording of an indictment and the evidence presented that is fatal only if it's material and prejudice the defendant's substantial rights. Is it your position that the defendant here, Ms. White, was unable to prepare an adequate defense based on the indictment?
Yes, Justice, it is. And this applies, well, first, if it is a part of the statutory allegation, the prejudice doesn't matter because it is always material. And so that goes into our alternative argument that it's material because it ties into a descriptive element of the offense. But I believe the record is clear that it did prejudice Ms. White. I believe that the indictment was misleading. If you look at the record, the defense focuses a lot on the fact that the writing did not purport to be an act of Mr. Halili's. So with that indictment, you know, they go into trial thinking that this is a defense, and it turns out that it doesn't seem, you know, taking the position that it may not be. And you have, the case law on this can get very confusing and convoluted. There are no clear answers. So with that going in, that's what she thought the defense was. That's what they moved for directed verdict on. And that's one of the main issues they hammered home with questioning the signature and issues like that during the trial. So as I was saying, so that ties into our alternative argument that variances that describe an element of the offense are sometimes material, and they are material if they are descriptive of an offense that defines the allowable unit of the prosecution and prejudices the defendant. Now, the allowable unit of prosecution turns on the gravamen of the offense, and here the gravamen is the portion of the forgery definition that says is an act of another who did not authorize that act, because that is the discrete unit of the offense. And so, as discussed earlier, everything ties into the definition of another, and by specifically identifying the other in this case, the state tied its proof to this element, and it becomes a material charge. And then, as I said, the prejudice is evident by the fact that she relied on this defense. The record supports that it was a critical portion, so the indictment affected her ability to prepare and defend case.
Is the assessment of whether a defendant was prejudiced by being unable to adequately prepare a defense dependent on what arguments the defendant chooses to raise at trial?
I believe the answer to that is yes. Under Golihar, those are some of the main concerns that they took in place in that case when deciding that the defendant had not been prejudiced. In that case, they said the defendant didn't rely on the difference between the serial numbers on go-karts, and that defendant had admitted to taking a go-kart. Here, it's much different. The record is clear that the idea was if the state could not prove that the act purported to be Mr. Halili's, she had a viable defense. So I do believe that the inquiry you can look at the trial to see and to show that it did actually have an effect. And I see that I'm on 5 minutes.
Counsel, you'll still have an additional 5, even if you use your full 20 here.
Thank you. Lastly, we have the issue is whether the court committed a reversible error when it admitted duplicative evidence during the punishment phase. The rules of evidence prohibit the admission of duplicative evidence. There are 6 factors to determine whether the evidence would be admissible in these circumstances. Those are whether the inherent probative force of the evidence, the proponent's need for the evidence, the tendency of the evidence to suggest a decision on an improper basis, the tendency to confuse or distract the jury, the tendency that the jury will give evidence undue weight, or the likelihood that the presentation will consume an inordinate amount of time or merely repeat evidence that is already admitted. In this case, the state was allowed to introduce multiple documentation of the same convictions in Ms. White's criminal history during the punishment phase. She admitted to these convictions to start, and they were for credit card abuse, debit card abuse, and fraudulent transfer. Then the state admitted its Exhibit 5, which was judgments of the convictions. So there was plenty to support her admission. It proved that she had been convicted of these offenses. But then on top of that, and over objections, they were allowed to admit Exhibits 10 and 11, which contained duplicates of the judgments, but also some other information such as the indictments and then the criminal docket sheet. And this was clearly duplicative of what was already been admitted. They had no probative value because they did nothing than to prove what had already been proven and what Ms. White had already admitted to. There was no need because they had this evidence in the admission. They suggested that Ms. White was more of a criminal than she was for the purpose of punishment, which would lead to a punishment on an improper basis.
How
They are all.
How did it lead to that conclusion?
Well, I believe that when you're presented with a stack of documents, it looks much worse than it actually is. You have the 3 convictions, but then you're seeing it repeated over and over. So there's almost a kind of multiplying effect to that. I think it creates the impression that there's a lot more going on than what there really is.
As part
And
of your, as part of your harm analysis, are you required then to distinguish between what the original evidence of the conviction that you're not objecting to and show that there would be a different result if the second evidence, or can you just throw it all in and say that because there was an adverse result, there was harm in the admission of the second evidence?
I believe that we have to show the harm as part of our burden on this one, considering that.
And so my question is, how do you distinguish between the jury's decision on the sentence based upon the original evidence versus the jury's decision based upon the duplicative evidence?
Well, I believe that you would look at the nature of the crime, the natures of the other crimes, compared it to the range of punishment, and see where she landed. I mean, I think in this case, she was assessed a $5,000 fine, which is within the range. I believe the range is up to 10,000, but it was a little over a $400 check. So I think that's a big difference there, and I believe that that's some evidence that the additional charges, the information those exhibits influenced them to assert a much heavier fine than what would probably be reasonable for that type of offense.
Well, certainly the punishment range was 2 years up to 10 years. And this 4 years was at the kind of lower of the range.
That's correct, but it's not only the 4 years, it's also the fine. So it's 4 years and $5,000 for a $400 check. And I think when looking at that, there's a real question, and I think it is an issue that there was something in the exhibits influenced the jury's decision to assess.
Are you relying on any particular case for the 6 factors that you mentioned in your argument?
Yes, Your Honor, and I believe that is cited in our brief, and that is Riley versus State, or excuse me, I'm sorry, that is Davis versus State, and that is, the site to that is 329 Southwest 3rd 798, Texas Criminal Appeals 2010.
Thank you.
Counsel, that's your time there. Thank you very much. You will still have 5 minutes for rebuttal. Mr. Van Zieben.
May it please the court. My name is Willem Van Zieben. I will be representing the state of Texas on this appeal. And I am happy to have this opportunity to be here to respond a little bit to the appellant's reply brief, which was filed last week. So
can you start with the duplicate judgments that were admitted, and were they material?
Yes, ma'am. I believe they were. The reason, so I was counsel for the state at trial. The reason I brought the pen packet first, which contained the 2 felony judgments, is I wanted to give the jury an idea of how long she had spent between her prior offenses, how much of that time she spent in prison, how much of that time she spent on probation, so they could get a fuller understanding of Miss White's criminal history. The reason I introduced all of the separate judgments is that those contained the indictments, which I figured would give the jury a more full understanding of her prior offenses. There's only so much you can get from a conviction for theft without knowing where the theft was from, how it was conducted, what the amount of the theft was, and all of those things I thought would better inform the jury of Miss White's prior history. And when I was doing so with Detective Hott on the stand, I did make it clear that there were 6 prior offenses that we were talking about in those 8 exhibits, 2 felonies, 4 misdemeanors. When my co-counsel, Mr. Tucker, did his open close, he made it clear that there were only 6 prior offenses. And then Mr. Haddock's defense counsel also made it clear to the jury that there were 6 prior offenses that we were talking about. So the jury was never confused by that information. They never misunderstood the nature of Miss White's prior history. And it seems that her primary disagreement, her primary reason for saying that it was duplicative and prejudiced her, is that she disagrees with the verdict. She thinks she got too much time. She thinks the fine was too large. And so she wants a reason to say the jury was wrong. But in this case, that was the jury's discretion. And that was the punishment they chose to give in this case. So with that, Your Honors, I'd like to turn to the legal sufficiency argument. And Ms. White, in her reply brief, she talked and worked from a case called Rajmatnam Singh versus State, which I think is a really, really useful case in understanding the modern test for variance under Golihar. So they say that a material variance prejudices the defendant's substantial rights, and then they give the test for Golihar, but then they define the three types of variance and their materiality. And the first one is a statutory allegation that defines the offense. Now, according to Ex parte Porter from Ms. White's original brief, the elements of the offense of forgery, as defined in the penal code, are the state only has to allege that a person forged a writing with the intent to defraud or harm another. In that case, the state didn't allege a manner and means, and the court held that it was appropriate to move forward on that indictment, and that indictment wasn't defective. Now, of course, we did define a manner and means. Justice Parker, you brought that up, saying that we stated that the forgery was an instrument that purported to be the act of another. And we were obliged to prove that fact by alleging that manner of means, and we did. We proved that Ms. White was not the originator of that instrument, thus satisfying the allegation that it must be another. And then we went on to add some detail to our allegation by saying that it was Mr. Halili. But Mr. Halili having originated the instrument is not an element of forgery. Otherwise, there would only be one forgery possible. In this case, we fall clearly under the Golihar test, because we did make an allegation that gave factual information to the defendant by which they could prepare their defense, and we alleged that it was Gino Halili. And I'd like to get to that in a second, because I do believe the jury could reasonably have found that it was the act of Gino Halili. But very briefly, under the Golihar test, as I stated in our brief, I really think the state pretty clearly wins on this issue. And I'd like to address the second factor first, which is that it would subject that the defective indictment could subject the defendant to the risk of being prosecuted later for the same offense. That's not the case here. We included the date, the time, the person that Ms. White passed the check to, and we included a photocopy of the check in the indictment. If we turned around at our next grand jury and attempted to indict her again for that same forgery, we would obviously be barred by jeopardy, and appropriately so. She's not subject to multiple prosecutions, and she never was in this case, which gets us to the first issue, which is whether she was adequately informed of the charges against her, whether the indictment, as it was written, adequately informed Ms. White of what the state accused her of doing. And I believe that it did. Not only did we allege the date and time on or about which it happened, we alleged the person to whom she passed the check. We stated that it was a pasta fina check. And most importantly of all, we included a photocopy of the check. She knew the check. We were accusing her of forging the entire process, and she prepared for trial accordingly. She did not prepare for trial depending on it having been the act of Gino Halili. She prepared for trial based on having passed that altered check, which was authorized by an individual who did not authorize it. So in that sense, she could not have been prejudiced by the indictment. And in a practical matter, she was not prejudiced by the indictment. For 2 full years, she had access in discovery, both to the offense reports in the case and to the video, the security video from the gas station that we showed at trial, in which she can watch herself walk in to that gas station, pass the check, and then leave when Mr. Manzoor called the police. So she was fully appraised of the charges against her, and she prepared her defense accordingly. So I would like to address next the argument that her defense attorney focused primarily on the indictment, and thus she was prejudiced by that. And I think I have two primary responses to that. The first, that depends on some speculation as to Mr. Haddock's intent while preparing for trial, what his trial strategy was, how it worked out. And that really goes beyond the record in this case. If she wanted to get that on the record, the appropriate avenue is in a motion for new trial. She could call Mr. Haddock to the stand and ask him what he'd been strategizing, the way that you would with, for example, ineffective assistance of counsel on appeal. But in this case, she didn't. And and because I was the trial attorney on this case, I do have some understanding of what went on with Mr. Haddix and the defense, but that doesn't matter because, of course, it's not part of the record on appeal. So it depends on speculation that's inappropriate on appeal to do. And in a larger sense, I would be cautious about an argument that a defense attorney's trial gamble is the deciding test for whether something's material or not. To say that Mr. Haddix took a gamble on winning on appeal or winning a directed verdict and didn't focus on other elements of the defense, it is speculative, but also I don't think that's the test for what makes a material variance, the actions of defense counsel. I think the test is the test as described in Golihar, and it's really more dependent on the defense's understanding and ability to understand the charge and the state's failures in indicting the case properly. So I think those are the appropriate places to focus rather than the defense strategy at trial. Now, Mr. Justice Doss, you asked a little bit about what the jury understood in terms of Mr. Halili having originated the check. And I think the evidence as it was before the jury at trial could justify a verdict that it was the act of Gino Halili. It was the authorizing act. The evidence that we had was that Ms. White passed what appeared to be and what was intended to appear to be a Pastafina payroll check. That even though it got the signature on the check did not appear to be that of Gino Halili, I can't really tell who that signature was intended to be, even if it was intended to be anyone at all. And I think we can speculate as to the reason for that. I would guess it's because Ms. White didn't know who signed Pastafina payroll checks, but again, that's outside the record. Overall, though, it did appear to purport to be a Pastafina payroll check, and the evidence at trial from Mr. Halili, both in direct and on cross, stated that he is the only individual at Pastafina of Granbury who is authorized to authorize payroll checks, that he hasn't given that authority to anybody else. It couldn't be any other individual who authorized a payroll check. So regardless of whose signature it was, I think the jury could reasonably have found that if a payroll check came from Grand Pastafina of Granbury, then it purported to be authorized by the person at Pastafina who authorizes such checks, which is Gino Halili. So if the court believes that the jury could reasonably have found that to be the case, you don't even need to get to the matter of variance. But if you don't find that to be reasonable, then you get to the matter of variance. And I think the Golihar test is the appropriate standard to analyze this case.
Let's say that the check had said Bill Smith or something on it instead of Mr. Halili or something we can't identify and recognize. Same result, different result.
I believe the same result, once again, and interestingly, it doesn't even need to purport to be the act of an actual person. There is case law out there, which I could have somewhere in my piles of case law that state that even when you allege a fictitious person as the originator of a check, it still is a forgery. So it doesn't have to be a real person. It doesn't have to allege the correct person. Now, I can imagine a situation in which we did allege Bill Smith was the originator of the check, and Bill Smith worked for, say, Pastafina of Stephenville. In that case, Ms. White really would have a very colorable argument that she was prejudiced, that she would believe that she was being accused of passing a check from Stephenville instead of Pastafina of Granbury, and that if she had prepared to defend a check that purported to be from this other person, then she could be prejudiced. But in this case, I don't think we get there, mostly because the photocopy of the check was included in the indictment. I really think that does a lot of work for informing the defendant fully of what they're accused of, which is, of course, why we include it in our indictments. Now, I believe that is, I believe that's everything, Your Honors, unless there's any questions from this court.
Members of the panel, any questions for Mr. Van Zieben? Being no questions, we'll go to the appellant for final rebuttal. Mr. Alderetti, you still have 5 minutes. And I've lost your video.
Okay. I'm frozen on my screen, so I'm not sure what's going on.
your audio is operable. We'll go with it.
Thank you. I'd like to first start by addressing the point that Appellee makes regarding ex parte order. And that is an older case. That's from 1992. And I don't believe it applies here. That case did rule that all the state had to show in the indictment was that a person commits offense if he forges a writing with the intent to defraud or harm another. However, that was in the motion to quash context. And since then, case law has been clear that if a statute has multiple means of proof, you can allege one or more than one, but if you pick one, you're confined to that one. And the act of another is part of the definition of forge, and it can't be set aside. It has to be considered. And then speaking to the Rasmussen case, the state has brought up the issue of whether Ms. White could be subject to another prosecution. And the test is or. She doesn't have to prove that here. She either has to prove that or that she was prejudiced. And I believe that the evidence shows that she was prejudiced. Now, the state argues that it's speculative to say that, but you can make inferences from what's on the record, and the record does show that this was a part of the case, and I think it played a much bigger part than what the state might lead one to believe. I mean, this was one of the primary defenses, and that stems from the fact that the indictment alleged that specifically that the act purported to be that of Gino Halili, and her strategy was that it would be to show that the act did not purport to be his. It had nothing to do with Mr. Halili, and I think that the record supports that. And obviously, the record doesn't clearly make a statement of that, this was my strategy, but it is supported. You can make inferences from the fact that he moved for directed verdict on the ground in the questioning he provided and the evidence he elicited at trial from Mr. Halili with the signature. Lastly, Justice Doss proposed the hypothetical, if it was a different name, would it be a different result? It absolutely would be a different result because that's a totally different offense. And that would also go to the materiality issue. You'd be if you put a different name, it totally changes the argument at trial. The other issue I'd like to raise is that the state takes the position that by being an act of Postefina, by having Postefina everywhere, being a Postefina check, it can be, the jury can take that as an act of Mr. Halili's. However, I believe that position is inconsistent. Number one, with the penal code. Penal code defines individuals and corporations separately, and under business law, you can impute the act of companies act through individuals. So you can take an individual's act and put it to a company, but you don't take a company's act and put it on the individual. So I think that there is a distinction. I think that because people and companies are separate under the definitions in the penal code and just under general civil law, that you can't just impute what might be a Postefina check to being Mr. Halili's act. It's much more specific. And when you make that specific allegation, it has to go there. And then as a final point, I would say that the material argument, or whether there was prejudice or Ms. White could be charged for the same crime, if as we argue, the element is so tied into the statute, it will be material regardless. So it doesn't necessarily have to, Ms. White doesn't necessarily have to show that if it is a critical part of the charge. I believe that's all that I have for my rebuttal.
All right, thank you, Mr. Aldretti. Counsel, I will advise you that the matter will be submitted to the panel on briefs and on the arguments of counsel, and that will conclude today's proceedings. I want to thank you for appearing virtually. I meant to mention it first. Here on the court, we're actually operating from 2 different cities. But the judges have multiple monitors. And so if I'm looking over here and it looks like I'm not paying attention, I may be looking at your brief and that we're just not stage presence enough to know. And so I want you to know sometimes if we look off and we are still trying to pay attention and keep up with your argument. So if you have any observations or comments that would be helpful to the court, we'd certainly welcome those. But we thank you for your presentations, and we hope that y'all have a good day, and we'll then be in recess. All right, this time we'll be in recess.